Good morning, everyone, and welcome to this WADA webinar on results management this morning. Today's session is the final session for international federations and major event organizations this year, and it's the latest topic in our series of webinars just days ahead of the introduction of the revised code at the start of next year. First of all, a few introductions. My name is Ben Nichols. I'm the Senior Media Relations and Communications Manager for WADA and the moderator for this session. It's a pleasure to introduce our presenter for today, Julien Sieverking, who is the Chief Legal Manager for WADA. We are also hoping to be joined by Thomas Capdevielle later in the session. Thomas is experiencing a few technical difficulties, but hopefully he will join us for the question and answer part of the session. We will have questions immediately following Julien's presentation, so please type these into us as we go along and we'll get through as many as we can. And without further ado, I will hand over to Julien to take us through the results management session. Thank you, Julien.
Good morning, everybody. We welcome you on board for this last webinar of 2014, held from snowy Montreal. The topic for today is results management, which is a key process in the fight against doping sports. An appropriate and timely results management process is necessary to ensure all anti-doping rule violations are duly dealt with in the respect of the code rules and the athlete's rights. This presentation will mainly follow the order of the recently published new guideline on results management that you can find on WADA website. For now, we have posted the English version. The French version should be posted before the end of the year holidays. So what is result management? There is no definition of result management in the code. However, if indicated that results management is the pre-hearing administration of potential anti-doping rule violations. The first question will find the variable is the anti-doping organization that initiated the sample collection. In non-analytical cases, the jurisdiction will fall on the ADO that first provided notice to the athlete or to the other person of the asserted anti-doping rule violation. It's not always easy to determine who is responsible for result management. So in order to ensure that any case leads to a decision and that proper result management is conducted, the code sets forth default jurisdiction. So in case of any problem, the IF in the International Federation will be the default jurisdiction, or if not, it will be as directed in the International Federation rules. In case of disputes between two potential result management authorities, WADA shall decide. A protocol on how to ask for a decision of WADA in such a situation is annexed to the result management guideline. But this question of jurisdiction is key, and as mentioned, it's not always easy to determine because, for example, when a foreign athlete is tested out of competition, for example, for France, Rune Anderson in Norway decides to test an Italian athlete trained in Norway, the default jurisdiction will have to be the duration. There are also some specific jurisdiction issues. For example, in cases WADA conduct testing, WADA will guide who will be result management authority. For major event, according to Article 711, the major organizer has primary responsibility in determining if an anti-doping rule violation was committed, but then the case is transferred to the International Federation for all the consequences beyond the event. For whereabout cases, the result management authority will be the anti-doping organization with whom the athletes file his or her whereabouts information, as the athletes are only required to file their whereabouts with one ADO. For passport cases, the passport custodian will be responsible for result management, even if another ADO ultimately prompted the adverse passport finding. Another situation that requires attention in this case, an athlete retired. If an athlete retires while the result management process is on the way, the competent RMA can continue with the case. If an anti-doping rule violation is discovered after an athlete has retired, then the competent result management at the time the violation was committed. Let's speak about three important principles to be taken into account in the result management process. First of all, the timeliness. Any case should be dealt with promptly. This is very important to ensure effective sports justice, to ensure the smooth running of the competition. There is no specific timeline in the code. However, we might say, as indicated in the result management guideline, that in a simple case, 6 months time between the reporting of an AF by a lab, for example, and a decision is appropriate. For sure, in some cases where there are difficult procedural questions and tricky scientific questions, for example, it could take longer, but as a rule, a simple case should be dealt with within a 6 months timeline. To avoid any undue delay, WADA has the possibility to bring a case directly before the CAS as stipulated in Article 13.3 of the Code. Before starting any result management process, it's important to ensure that the violation you want to prosecute is not time-bound. It's currently 8 years, but as of 1st of January, the statute of limitation, it will be 10 years. Confidentiality shall also be respected during all the process. The result management phase is confidential. You have to deal with confidential information, sometimes medical information, whereabouts, so it's very important that this phase is kept confidential, as breaches of confidentiality may have serious consequences and notably significant legal claims from part of an athlete, for example. So it's also important to ensure that all ADOs comply with the applicable law and also with the WADA standard for data protection. So, in case of adverse analytical finding reported by a lab, the first thing to conduct is what is called the initial review, as indicated in Article 7.2 of the Code. You have to review whether some irregularities, in other words, departure from the international standards, occurred. How you can do that? First, by reviewing all the documentation of the case, the DCO report, and to ensure the chain of custody, and also all the doping control process itself was fully compliant with the rule. The athlete was properly notified, has properly signed the doping control form. Also, by reviewing the laboratory analysis documents and the sample collection process. At that time, you don't have to make an in-depth review of all the documents, but just a first review to ensure that there is no apparent departure. If any irregularity is highlighted, the question to be asked at that stage is whether this irregularity undermines the validity of the adverse analytical finding. If there is a major departure from the standards, the case can be declared void. We have already 2 or 3 cases at CAS where a case had been terminated for departure from the standard, for example, in the Varys case. Another part of the initial review is to control whether the athlete has a therapeutic use exemption for the substance reported. If there is a TUE that is relevant to the finding, then no need to prosecute the case. However, it's not enough to have a TUE. Once you have established that an athlete had a TUE for the substance reported, you also have to check whether the level of the substance detected in the sample matches the dosage authorized in the TUE, because in case an athlete exceeds the authorized dosage, this constitutes an anti-doping rule violation and the process shall continue. For sure, if there is no TUE, the process shall continue also. A specific case of glucocorticoids and beta-2 agonists, For glucocorticosteroids, some routes of administration are authorized, so all AF for gluco do not constitute anti-doping rule violations. So it's important to proceed at that stage to verify what was the routes. On some occasion, the athlete indicate the route on the doping control form. If not, you may contact the athlete to ask him about or her about the route of administration. It's also important to verify that there is a match between the dosage and the route declared by the athlete and the laboratory finding. For a beta-2 agonist, some are authorized, some not. For example, for a salbutamol or formoterol, if the level reported by the lab exceeds the limits set in the list, it is not presumed to be an intended therapeutic use and the case should be prosecuted. At that time, the burden is on the athlete. This was an intended therapeutic use, but to do so, he has to submit to a controlled pharmacokinetic study. On that specific point, I ask you to see the medical recommendation that you can find on the WADA website. In case you have established that the departure makes the case void or that there is a TB and you decide not to bring the case forward, it is important to notify WADA, the athlete, the NADO, and the competent IF of your decision, given that this decision that not to bring the case forward can be appealed. Again, as for any notification, it's important that it is done timely in order not to unnecessarily delay the result management process. After the initial review, if you consider that the athlete has to answer to an ADRV, the athlete shall be notified in writing. You have the list of all the information that should be included in this notification. This is also reflected in Article 7.3 of the Code. It's important to mention that it's possible to mix this notification with the charge itself and also with the provisional suspension. You can see this more in detail under section 343 in the result management guideline. As regards the B sample analysis, not only the athlete can request it, also the ADO may request the B sample analysis. In any case, whatever the B sample analysis is requested by the athlete or the ADO, the athlete has the right to attend the B sample be presented. Again, in the various case, it's a CAS decision. CAS considered that no sanction could be imposed on the athlete given that this right to attend the B sample was not respected, and the CAS declared that the decision should be to quit the athlete. So it's very important to ensure that this athlete's right is respected. As regards the and last point on the attendance to the B sample opening, in case the athlete cannot take part, you can always appoint an independent witness, and this independent witness, it's not defined in the code, but it's a witness that should be independent from the lab, from the athlete, and from the ADO prosecuting the case. Some ADO rules require a notary, but this is not mandatory under the code. As regards the timing of the B sample analysis, it's stipulated that it should be proceeded with within 7 days, according to the ISL, but this is not a mandatory deadline in the sense that this deadline exists only to protect the integrity of the sample, given that with the time some sample may degrade. So it's important to proceed to that timely. However, it's not within 7 days. It is not a major issue. As regards the attempt to accommodate the athletes, it's case-by-case basis, but reasonable attempts should be made to accommodate the athlete to ensure he can be present, even if the B sample analysis is requested by the ADO. The B sample analysis shall always be proceeded with in the same laboratory as the A sample. This is very important. There is only one exception under the ISL. In case the lab that proceeded with the A sample analysis lacks of specific technology, for example, some labs do not have the possibility to proceed with RMS analysis, then the sample can be transferred to another laboratory. But in this case, both the A and B, or the split of the A and the B, shall be sent to another laboratory who will then proceed with the A and B analysis again. In case the B sample does not confirm the A sample result, no further action is required and the case can obviously be closed, and in case the B sample analysis confirms the A, the process continues. As regards the atypical finding, it's Article 7.4 of the code. What is an atypical finding? It's a result of a lab that requires further investigation. It means you cannot prosecute the case, take further steps before continuing with the process. In the result management guideline, you will find a list of all the situations where an ATF may be reported and the nature of investigation that shall be conducted for each of them. For example, a mass in some cases of 19NA, and in case of human growth hormone or as well as a notification of adverse atypical finding, the athlete shall not be notified before the investigation is completed, and this investigation may include further testing. There are two exceptions. The first one is really important. In case an ATF for human chorionic gonadotropin is reported for a male athlete, the athlete shall be informed immediately the consequence of pathology like a cancer. So it's very important that you notify the athlete immediately. Also, in some cases, the lab may need to proceed with the B sample analysis even for an ATF. So in this case, for sure, the athlete also shall be notified so he or she can attend the B sample analysis. The conclusions of ATF investigation are twofold. Either you can conclude that it's an AF and the result management can go on, or you should be conducting additional testing on the athlete. The review of athlete passport cases, I'm not going to speak longer on that today because we are planning maybe next year to have a specific webinar on that question of an athlete blood passport, an athlete biological passport. So as you know, you have two kinds of passports, the urine passport, the steroidal passport, and the blood passport. All these passports' objective is to see the indirect effect of doping on certain parameters. For the steroidal passports, all athletes are included in this, given that it can be taken from regular urine sample, when for blood passports, not all athletes, given that it requires specific controls and with rigid protocols as regards the transport, the timing, and so on. Everything will be reported always in ADAMS, and this is ADAMS that will notify the anti-doping organization that there is an ATPF. Then you have here on the slide a description of the process, but I recommend, if you want to see that more in detail, that you have a look at the athlete biological passport as well as Article 7.5 of the code. We will have also a specific section in the result management guideline in respect of ABP case failure. The result management to be followed is detailed in the ISTI. As mentioned earlier on jurisdiction, the competent RMA will be the ADO with whom the athlete files his or her whereabouts information. And in case an athlete is included in both the NADO and the IF RTPs, there should be an agreement between both organizations as regards which one will be responsible for result management, and in case of dispute, WADA will decide. There is a slight change in the new code as regards the combination of whereabout failures. To be considered a whereabout violation and an ADRV, an athlete should have 3 strikes within 18 months, and as of next year, it will, as of 1st of January, it will be 3 strikes, but in a limited period of 12 months. It means that for any strike that occurred after January 1st, you will have to look back only 12 months and not 18 months to see whether the athlete had previous strike recorded. The review of other anti-doping rule violations, the non-analytical violation, which are in fact most ADRV under the code, refusal, tampering, evading, administration, and so on. So for result management of these cases, when you become aware of a potential violation, you have to conduct a follow-up investigation. So on which basis to conduct this investigation? You should have a look at the evidence gathering section in the ISTI article 12.3, but the evidence available could be the doping control officer reports. This will be key in case of refusal or evading. Also the athlete or other person admission, statements, testimonies, other kind of evidence can be used, documentary evidence, police reports, picture, and so on. The code indicates that the anti-doping rule violation can be established by any reliable means. So any solid evidence can be used, and it's important that the result management authority establish a complete file with all the evidence in order to submit it to the hearing panel. The complete file with evidence should also be submitted to the athlete in advance of the hearing. Now, a new topic that is under the 2015 code, it's the prohibited association. So I'm not going to enter into the detail of the 3 situations where an athlete of what kind of person fall within the prohibited association. You have this under Article 2.10 of the code. But once you become aware of a potential case of prohibited association, the first thing is that you have to advise the athlete or the other person in writing of the disqualifying status of the athlete support personnel. Then the athlete has a possibility to answer to that, and for example, the athlete can establish that he cannot reasonably avoid the association. For example, as mentioned in the comments to this article, when an athlete is coached by his father or by his wife or her husband, the association cannot be reasonably avoided, so no case can be instigated. The athlete can also have the possibility to establish that the athlete support personnel in question does not fall within one of the 3 categories of Article 2.10. If the ADO considers that these explanations are not satisfactory and that the association continues, then result management shall be instigated like in any other anti-doping rule violation case. Once you have concluded that the immediate took place, you should notify the athlete, the NADO, the International Federation, and WADA. And again, the athlete shall be provided with all supporting documents and evidence in advance. This is a key principle to be respected. For provisional suspension, there are no major changes in the 2015 code, so it's mandatory for non-specified substance, optional for accept voluntarily provisional suspension. In this case, it should be credited against the final sanction to be determined. There is a new rule as regards provisional suspension on contaminated product. If the athlete can establish that the AAF is the consequence of the administration of a contaminated product, then he can avoid the provisional suspension. At that stage, the athlete has not to establish this with a very high standard of proof. He should just establish this, that it is likely. So it's really it's not a sound review at that stage. In case a provisional suspension is imposed, it's important that either there is a provisional hearing or that the hearing will take place shortly after the decision to impose a provisional suspension, notably to avoid that the provisional suspension serves is then longer than the final sanction, which could trigger for sure some problems. The hearing process. It's up to the ADO to appoint an independent panel and to determine the profile, experience, and tenure of the member. It's important that this tribunal is impartial. It's also important that at least one of the three persons composing the tribunal has a legal background. The other member of the tribunal should provide a collective expertise in relevant fields, medicine, science, sports. Ex-athletes can also be parts of the process. But again, it's very important that all these persons are fully impartial in their decision process. As regards the jurisdiction, it's important that the hearing panel check at the beginning of that they have jurisdiction. Once the athlete has been notified that the case will be heard by a panel, it's important that the hearing takes place timely. There's a recommendation of 14 days in the result management guideline, but this is not mandatory. However, as soon as a decision is rendered, it should be notified to all the parties within 20 days. This is mandatory under the code. It's important to notify all the parties with the right of appeal, because in case it's not done, and we had a case recently where decision was notified to WADA 2 years after it had been rendered, and it's a decision that was not compliant, that we had to appeal when the athlete had already served the suspension 1 year ago. So to ensure proper administration of the case and a smooth running of the competition, notification is always key. You have here all the process, the basic procedural rights that have to be respected. It's also under the code. I'm not going to read this list again. The decision itself, so as mentioned, should be rendered very shortly after the hearing. Also, in very urgent cases, you may decide to render only the results of the decision and then to notify the athlete and other parties with the reasoning at a later stage. Again, proper notification of all the parties with the right of appeal is key. As regards the content of the decision, it's important that it's fully reasoned and comprehensive. You have a template of decision in the result management guidelines, so I will also recommend you have a look at it to ensure all the points listed on that slide and in this section of the guidelines are in the decision rendered by your anti-doping tribunal. Another point that sometimes is problematic is the beginning of the period of suspension, because the rule is clear: the suspension shall start on the date of the hearing decision, but many times there are some mistakes by a hearing panel in this respect. So in case there are only a few exceptions where the suspension starts can be backdated, for example, when provisional suspension has been served and is to be credited, or when the process was delayed but the athlete was not responsible of that delay, or in the case of timely admission, it's Article 10.11.2 by the athlete. In this case, the starts of the suspension can be backdated at the maximum to the sample collection date. The publication, it's important to say that it's part of the sanction and it has to be made 20 days from the decision, after the decision has been rendered. You have a list here of the information that should be published, and the minimum publication should be placing the required information on the ADO website for the longer of 1 month or the duration of the ineligibility period. So if the athlete is suspended for 4 years, the sanction will be published on the website for 4 years. If it's a reprimand, the sanction shall be published for 1 month. It's not mandatory for minor to publish the decision in case the athlete involved is a minor. Other very important point is the post-decision duties, prohibition of participation, to ensure that the sanction is respected by the athlete or other person, and that any breach of the statutes during the ineligibility period shall be prosecuted. As regards the statutes during ineligibility, it's very extensive. It's the athlete or other person cannot take part in the sport in any capacity. I refer on this basis to Article 10.12.1. Also, the athlete shall remain available for testing during the suspension. The return to training, there is a new article on that. The last 2 months, the shorter of the last 2 months or the last quarter of the suspension, the athlete is allowed to go back to train with in official training facilities or with his team. Appeals. So any decision can be appealed if it's an international level athlete to the Court of Arbitration for Sport. Regional Appeals Panel. The same principle apply for the appeal hearing, a timely hearing, a fair and impartial hearing panel. Last point I wanted to discuss today is substantial assistance. This is a key principle because it's important in order to gather additional information on potential doping cases, but it cannot be awarded in all cases. The principle is quite clear. The information provided by the athlete or that other person shall lead to the discovery or establishment of an ADRV by a third party. This is really the obligation of results. As regards the jurisdiction, who has to decide and to review if substantial assistance exists or not in a case? So before a final decision, it's the result management authority. Once a decision is final, because in some cases an athlete who is serving a period of ineligibility becomes aware of potential anti-doping rule violation by others and wants to denounce it. So in case the decision is final already, it's still the result management authority, but the WADA and the International Federation shall agree to the proposed reduction. Under the new code, there are also specific competences for WADA in case of substantial assistance. So I recommend you have a look at Article 10.6.1, 10.6.2, and 10.6.3 of the 2015 code. Substantial assistance cannot be granted in all cases. There are some very important requirements. The athlete shall make a full disclosure and shall fully cooperate with the investigation, and also until a decision is rendered. In the other cases, it means the athlete has to provide his statement in writing and to sign it, and has to accept to testify in other hearing if required to do so. So it's important to mention that in case an athlete does not fulfill this condition, the part of his sanction that had been partially suspended can be reinstated. So substantial assistance is not something that is granted forever. It can be reinstated in case the athlete does not fulfill all the conditions.